He was the senior partner who'd signed my termination letter the same week he accepted my biggest case win as his own. I didn't smile when I saw him walk into the courtroom. I waited. I was 29 when I passed the bar. Not the first in my family to try. My father had studied 2 years of pre-law before the money ran out and he went back to installing drywall in Phoenix. But the first to actually finish. I remember calling him from the parking lot outside the testing center, sitting in my car with the engine off because my hands were shaking too much to drive. He cried. I didn't tell him I almost hadn't made it, that I'd failed the essay portion the first time, that I'd spent 4 months retaking practice exams at the kitchen table of the apartment I shared with 2 other women, that I'd eaten rice and pinto beans for 11 straight days because I couldn't afford anything else, and I refused to ask my parents for money they didn't have. None of that mattered the day I walked into Harwick and Associates and shook the hand of a man named Sterling Croft. He was 61, silver-haired, and he had the kind of handshake that told you he'd been doing it long enough to make it feel like a statement. He was the founding partner. His name was on the glass doors. His portrait hung in the lobby, oil on canvas, the kind that law firms commission when they want you to understand that permanence is the whole point. He looked at my resume the way people look at a menu in a restaurant they didn't choose, and he said, "We'll start you in document review." I said, "Thank you." I didn't say what I was thinking, which was, I graduated 3rd in my class. I clerked for a federal judge. I won a moot court championship. I am 29 years old, and I am already better at this than half the associates you have. I said thank you, and I went to document review, and I worked. The firm handled mostly corporate litigation, breach of contract, intellectual property disputes, the occasional employment case that slipped in when a client needed full-service representation. My first year, I reviewed contracts until my eyes felt like sandpaper. My second year, they let me draft motions. My third year, a case landed on the desk of a junior partner named Vincent, and Vincent had a conflict of interest he hadn't disclosed until the day before deposition prep. And the client, a biotech company called Novarin, needed someone to step in immediately. I was the one who stepped in. The case was a patent dispute. Novarin had developed a compound used in a particular class of blood pressure medication, and a competitor had filed a claim alleging prior art. The competing claim was thin. I saw it within 2 hours of reading the filing. But thin claims have won before when the opposing counsel is underprepared and the lead attorney on the other side had 30 years of courtroom experience to my 3. I worked 18 days straight. I don't mean I worked long hours. I mean I worked. I slept 4 hours a night on a good night. I ordered dinner to the office so often the receptionist started leaving menus on my chair as a joke. I built the counter-argument from the ground up, found 3 prior publications that undermined the competitor's timeline, deposed 2 of their own expert witnesses in a way that turned their testimony around, and walked into the courtroom with a case so tight you could have pressed a flower in it. We won. Full summary judgment. The judge praised the brief in his written opinion, which almost never happens. Sterling Croft called me into his office the following Monday. I remember what I was wearing. A gray blazer I'd bought secondhand, a white shirt I'd ironed twice that morning because the collar kept flipping. I sat across from him at his desk, which was the size of a small country, and he said, "The Novarin case was a significant win for the firm." "Thank you," I said. "I'm glad the approach worked." He nodded slowly, the way people nod when they're already thinking about the next thing they want to say. "Going forward, I'll be taking point on the Novarin relationship. They're a Tier 1 client now, and Tier 1 clients need senior partner oversight." I looked at him. "Of course," I said. "I'll brief you on everything." "Good." He paused. "You did solid work. Keep it up." That was all. I went back to my office and sat in my chair for a long moment, looking at the city through the window. Phoenix in October is still warm enough to feel like summer. The light comes in flat and golden and a little merciless, and the buildings in the distance shimmer like they might not be entirely real. I thought about my father, about the drywall he'd been installing that week in a new development outside Scottsdale. I thought about the 11 days of rice and pinto beans. I thought about the federal judge I'd clerked for, who had once told me, "The law rewards patience. Patience and precision. Everything else is noise." I decided to be patient. For 2 more years, I was patient. I took every case no one else wanted. I stayed late. I came in early. I won cases, not all of them. Nobody wins all of them, but enough. I built a reputation inside the firm as someone you called when a situation was genuinely difficult, not just technically complex. There's a difference. Technically complex is something you can solve with enough research. Genuinely difficult is something where the facts are bad, or the client is difficult, or the opposing counsel is good, or all three at once, and you have to find a way through that doesn't exist until you make it. I was good at finding the way through. What I was not good at was making myself visible to the people who controlled whether any of that mattered. I didn't golf. I didn't drink at the partners' happy hours because I was usually still working. I didn't have the right school on my diploma. I'd gone to a good state school on scholarship, not the kind of school that got you included in the conversations that happened at the back tables of certain restaurants where partners decided who was next in line for what. Sterling Croft noticed my work exactly when it was useful to him and exactly not at all the rest of the time. The second case happened in my 5th year. A client named Hargrove Industrial had been sued by a former employee over a non-compete clause that, frankly, had been drafted badly. I'd reviewed it when I first joined the firm and had flagged 3 potential weaknesses in a memo that had apparently gone nowhere. The case was assigned to a senior associate named Marcus. No, not the Marcus. This was a different one. A man who'd been at the firm 8 years and who had a tendency to speak in meetings with great confidence about things he'd only half read, and Marcus managed the first round of motions adequately and then had a family emergency that pulled him out of the country for 6 weeks. Again, I stepped in. The non-compete case was messier than the Novarin dispute. The employee who'd filed suit was sympathetic. A single mother who'd been offered a better-paying job at a competitor and was now being threatened with injunctive relief that would prevent her from taking it. My personal feelings about the case were complicated. My professional obligation was to my client. I kept those 2 things in separate rooms in my head, and I did my job. What I found, 3 weeks into discovery, was something I hadn't expected. The clause she'd signed was indeed enforceable under Arizona law, but the company had applied it selectively. There were 2 other former employees, both men who had gone to competitors without consequence. I documented everything. I brought it to Sterling Croft before I filed anything, because what I'd found changed the firm's entire legal strategy and he needed to know. He listened. He asked questions. He took the folder I handed him and said he'd review it overnight. The next morning, he called a meeting with the client and presented the new strategy as his own analysis. I know because I was in the meeting. I sat in the corner, the way junior associates sit in corners during client meetings, and I listened to him walk through findings I had made, arguments I had constructed, a strategic pivot I had identified at 11:30 at night while eating a granola bar at my desk. And I watched the client nod and say, "Sterling, this is exactly why we trust this firm." Sterling Croft said, "We take care of our clients." He did not say my name once. I drove home that night on the I-10 with the radio off. I thought about my father again. He'd hurt his back that summer, a bad slip on a job site, and was on modified duty, which meant reduced hours, which meant reduced pay. And my parents were fine. They were managing. They didn't need anything from me, but I thought about it. I thought about why I had become a lawyer. It was not because I loved the law. I respect the law. That is different. It was because I was good at it, and because being good at something that mattered felt like the only reliable form of permanence I understood. I thought about leaving the firm. I didn't leave. Not then. I stayed because I was 3 years from making partner eligibility, and because I had student loans that still had 6 years on them, and because I am stubborn in a way that sometimes looks like patience but is actually just refusal to let someone else decide when I'm done. The end of my time at Harwick and Associates came not because I chose to go. It came because Sterling Croft made a decision. There was a hiring freeze. I learned about it in a firm-wide email on a Tuesday morning. 3 associates were being let go. The criteria were performance and strategic alignment, which is the kind of language law firms use when they want to say, "We chose," without admitting they chose. My name was on the list. I read the email 3 times. Then I closed my laptop and went to the window and looked at Phoenix again. The same city, the same flat gold light, and I felt something I had not allowed myself to feel in 5 years. Not anger, not grief. Something quieter and colder than either of those. I thought, he took everything I'd built and then he cut me loose so I couldn't take it back. I said nothing. I collected my things. I shook hands with the people who deserved handshakes. I did not go to Sterling Croft's office. I did not send an email. I left the building at 2:15 on a Tuesday afternoon, got into my car, and drove. I called my father from the freeway. He didn't answer, he was probably on a job site, so I left a voicemail that said I loved him and that I'd call again soon and that everything was fine. Then I pulled over at a gas station outside Tempe and sat in the parking lot for 20 minutes doing nothing. Then I drove home, opened my laptop, and started writing. Not a complaint, not a grievance. I opened the case files I had copies of, my own work product, my own drafts and memos and research notes, everything with my name on it or my initials in the metadata, and I started cataloging. I also called a friend from law school who now worked in employment litigation. I said, hypothetically, if a senior partner repeatedly presented a junior attorney's work as his own and then terminated that attorney during a discretionary layoff, what would that look like from a legal standpoint? She was quiet for a moment. Then she said, that would look like a lot of things depending on the documentation. I said, I have documentation. She said, then it would look like a case. I spent the next 4 months doing what I do. I researched, I organized, I prepared. I also, during that time, passed the Arizona State Bar's Ethics Committee review for independent practice, secured a small office suite in a shared workspace in Midtown Phoenix with 2 other solo practitioners, and took on 3 clients, small cases, the kind established firms don't want, the kind that are technically complex and genuinely difficult and where the client has very little money and a real problem. I also filed a complaint. Not a lawsuit, not yet. A formal complaint with the firm's managing partner with copies to the state bar, documenting the specific instances in which my work product had been attributed to Sterling Croft without acknowledgement. I attached exhibits, 47 pages of exhibits. I'd been thorough. I am always thorough. The response came 6 weeks later in the form of a letter from the firm's outside counsel, which is when I knew I'd hit something real. Firms don't hire outside counsel to respond to complaints that don't concern them, but the letter is not the moment I want to tell you about. The moment I want to tell you about happened 8 months after I left Harwick & Associates on a Thursday evening in February at a continuing legal education conference at the Arizona Biltmore. The Biltmore is a Frank Lloyd Wright property, or a Wright-inspired one, depending on who you ask, with those long horizontal lines and the geometric tile and the kind of grounds that make Phoenix feel, for a few hours, like it might be capable of elegance. The Sile conference was the kind of event I would have attended as a Harwick associate and stood near the buffet making careful conversation. Now I attended as a solo practitioner with a growing caseload and a complaint pending against one of the city's established firms, and I knew almost nobody in the room, and I was fine with that. I had registered under my full name, Delia Vance. He didn't know I was there until I walked up to the registration table at the same moment he did. Sterling Croft was presenting on ethics in client relationships. I found that genuinely funny in a way I didn't let show on my face. He looked up from the registration table and saw me, and something moved behind his eyes that wasn't quite recognition at first, more like the kind of processing that happens when your brain sees something it filed in the category of no longer a factor and has to update the file. Then recognition came, and with it, something else. Not guilt. I don't think he is capable of guilt in the way most people experience it. Something closer to assessment. He said, Delia. Like we were old colleagues at a reunion. I said, Sterling. There was a woman next to him, another partner from the firm I didn't know well. There were 2 associates, young, the way I had been young when I'd walked into that building in my second-hand blazer. The registration table volunteer handed me my badge and lanyard. Sterling glanced at my badge. He said, with the particular smile of a man who's very good at performing graciousness, starting out on your own, I see. That's admirable. Solo practice takes a certain kind of resilience. He said resilience the way you'd say quaint. He said admirable the way you'd say brave of you. He looked at my badge the way he had once looked at my resume, with the particular disregard of someone who has already placed you and found the placement satisfactory. The 2 young associates were watching. The other partner was checking her phone. The volunteer at the table was politely pretending to look at something else. I took my badge. I held it for a moment. Then I said, the bar's ethics committee opened formal review on the attribution complaint last month. I thought you should know in case you wanted to prepare remarks for your session tonight. I paused. On ethics and client relationships. The woman partner looked up from her phone. One of the young associates very carefully looked at the floor. Sterling Croft's face did not go white. He is too controlled for that. But something in it, stilled in a way that reminded me of a pond after you drop a stone in. That moment when the water has already registered the disturbance but hasn't yet decided what shape to make of it. He said nothing for a long moment. I said, "Good luck with your presentation," and I walked into the conference room. I spent the rest of that evening listening to panels on arbitration clauses and discovery reform and sitting in the back of Sterling Croft's ethics session, where he was very polished and said all the right things, and where I watched him and he was careful, very careful, not to look at the back row once. Afterward, one of the young associates from the registration table found me during the cocktail hour. She was maybe 26, with the careful posture of someone who has been told many times to take up less space. She introduced herself and said she'd overheard what I said at the table and she wanted to know. She said this carefully, like she was testing the weight of each word, if I had actually filed a complaint or if that had been a tactic. I told her it was both. She nodded slowly. She said, "I've been at the firm 2 years." She said it the way people say things that contain more than the thing itself. I gave her my card. The ethics review took 11 more months. At the end of it, the firm settled. Not an admission of liability, it never is, that's not how these things work. But a settlement, and a formal acknowledgement in the firm's internal records of the work product at issue, and a non-disclosure agreement that covered the financial terms, which I signed, and the terms of which I will not describe here. What I will tell you is that I used part of what I received to pay off the remainder of my student loans, 7 years early. I paid off the last installment on a Wednesday morning, and then I called my father, and this time he answered, and I told him, and he was quiet for a moment, and then he said, "Baby girl, I always knew you were going to figure it out." He didn't know the whole story. He didn't know the whole story. He didn't need to. I also hired that young associate from the cocktail hour. She had left Harwick and Associates 6 weeks after the conference on her own terms, with documentation of her own. Her name is on the door of our office now, right next to mine. The last time I heard Sterling Croft's name was from a colleague who mentioned, over coffee, that he had announced early retirement, 63 years old. He would be pursuing private consulting work, the announcement said. I thought about that for a moment. Private consulting work is what people say when the alternative is silence. I thought about the oil portrait in the lobby, the permanent kind, the one that's supposed to say the building will outlast you. I thought about my father's hands, the way they looked after 30 years of work, rough and exact and capable of things that don't get written down anywhere. Then I finished my coffee and went back to my office, where I had 3 cases open and a 4th that had just come in that afternoon, a woman trying to enforce a contract that a much larger company was hoping she'd be too tired to fight. She wasn't too tired. And neither, it turned out, was I. I keep thinking about the registration table at the Biltmore, the way Sterling reached for his badge with the same unhurried confidence he'd carried into every room I'd ever watched him walk into, and how, in the span of about 12 seconds, something in that confidence shifted, not broke. Sterling Croft is not the kind of man who breaks in public, but shifted, went somewhere quieter and more careful. I've thought about that moment more than I expected to. What I understand now, in a way I couldn't have at 29, is that nothing that happened to me at that firm was random. Sterling didn't take credit for my work because he was careless. He did it because the system around him had never once required him not to. Nobody had documented anything. Nobody had pushed back. The structure of the place, the portraits, the mahogany, the unspoken rules about who sits in the corner and who sits at the head, was designed to make that kind of taking feel like natural order. I was young and I was grateful to be there, and I was working too hard to look up and name what was happening. That's not self-blame. That's just the truth about how those places work, and how long it can take to understand the difference between earning your place and being used to fill one. What changed everything? The only thing that actually changed anything was that I kept records, not out of suspicion, not because I saw the end coming. I kept records because I was trained to, because a federal judge I clerked for told me once that the most important habit a lawyer can build is the habit of documentation. That memory is impressionistic and paper is precise. I was doing what I'd been taught. The integrity I was practicing was professional before it was personal, and it became personal when I needed it to be. I think about that young associate who found me at the cocktail hour, 26 years old, careful posture, testing the weight of every word before she said it. She'd been at the firm 2 years and she already knew something was wrong. She just didn't know yet that knowing something is wrong and being able to prove it are 2 different kinds of power, and that the second one requires work. She did that work. She built what she needed. And when she left on her own terms. Her name is on the door of our office now. I'm not telling this story because I want credit. I spent enough years not getting credit to understand that credit, in the end, is the least important part. What I want, what I think is worth saying out loud, is that the version of me who sat in that parking lot outside Tempe, engine off, thinking she'd lost 5 years to nothing, was wrong. Those 5 years were not wasted. Every brief I wrote, every deposition I ran, every late night I spent at my desk with a granola bar and a legal pad, all of it was mine. Sterling Croft could put his name on a strategy. He could not put his name on what I knew how to do. That's the thing nobody tells you when you're starting out. Your competence is not stored in someone else's filing cabinet. It goes with you. Always. My father still doesn't know the full story. He knows I left, that I built something, that the loans are paid. He knows I'm okay. Some mornings, when I'm driving in early, before the city gets loud, I think about his hands, what 30 years of work looks like in a person's hands, and I think about what I am building and what I want it to look like in 30 years. Not the office, not the cases, the quality of the work, whether I was honest, whether I showed up when it was hard, whether the people who came through my door felt like they were treated with fairness by someone who had enough spine to mean it. That's the only kind of record that matters in the long run. And it's the only kind nobody can take from you.